Good evening. Let's light up the darkness. I am so happy to be learning with you right now. I had a stressful day. Ridiculous. Matters from the distant past suddenly reared their head. Like legal questions from issues long ago, stuff that no one has cared about in 20 years. Suddenly we have to find documents and show that everything was done correctly. It's such a hassle. It's unbelievable. And now, instead of thinking about that, we could just learn together. I mean, it's just so great. Who's in the house? John in Maine, Sharon in New Jersey, Melissa in Great Neck, Nancy in North Carolina, Ryan wishing everyone a good evening, Shandora in the Bronx, Gosia in Chicago, Bella in Florida, Peggy in Colorado, Paul in the Great Northwest, Joe in the Inland Empire, Jonathan says shalom y'all. Oh, Paula loves the shirt. There you go. That's an AT-shirt. We have a shop. Did you know that? They just create the shirts as needed, so we don't administer the shop. But there's really cool designs in there. I mean, I think they're cool. I designed them. But yeah, Nina, put the link in the comments, please, if you're listening. I think it's shop.accidentaltalmudist.org, and this is one of those shirts. Peggy likes it too. Paula, oh, one of those days. Oh, yes. Ryan, time to unwind. Amen. Amen. Marjorie in Georgia. Ella says shalom. Marie in Freeport. It is pretty funny. What we're talking about on today's daf is lost legal documents that are found again. We need to find these old legal documents that were archived. I mean, so long ago. Who has such records? But, we've activated all the troops, everyone who was involved so many years ago, and hopefully one of us in our records can find what we need. We know we did it correctly. We just need to show it. Okay, anyway. Where are we holding? This is page 27 here in Tractate Gittin, the 19th volume of the Talmud. These are the laws of divorce. We're in chapter 3. Today we're discussing Mishna number 3. So what happens if a bill of divorce, a get that someone lost, is found? And what do you do with it? I mean, obviously you would return it, right? Well, wait a minute. Think about this. If you find a get that was a bill of divorce that a man wrote up, and then he gave it to his agent to deliver to his wife, right? So when she receives it from the agent, that's when she becomes divorced. Now, maybe the agent lost the get, so he never delivered it. And then he went back to the husband and he said, I lost the get. So then the husband might have thought, you know what? This is a divine intervention. You lost the get because I was hasty in deciding I was going to divorce my wife. And now that this happened, you know what? Forget it. She and I will go to counseling and we'll work it out. Forget the get. But then somebody comes along and finds this get that was lost, sees, well, it was written by so-and-so to his wife so-and-so. Must be hers. I'll give it to her. And then when this, person who just wants to do a good deed returns the lost item to her, he actually creates the divorce at that moment. Massive problem, right? So it's not a simple issue. So let's see how the sages handled this question. Mishnah number 3 in chapter 3. With regard to an agent who brings a bill of divorce and it was lost from him, so the agent lost it. If he finds it immediately, well, then the bill of divorce is valid. But if not, then it is not valid, as it is possible that the bill of divorce that he found is not the same one that he lost. And this second bill of divorce belongs to someone else whose name and wife's name are identical to the names of the husband and the wife in the lost bill of divorce. However, if he found it in a chafisa, which is a box, or in a deluskima, which is a will, that he knows is his, or if he recognizes the actual bill of divorce, then it is valid. So we're not getting to the question of, we, the random person, find somebody else's bill of divorce. Should we deliver it to the woman named in the bill of divorce? We're not on that question yet. But what if the agent who lost it finds it again, right? So can he be sure that this get is the one that he lost? Remember, in the ancient world, very often you could find a person named, Levi ben Shimon. It was not such an uncommon occurrence to have a Levi ben Shimon. So if there were a lot of Levi, the son of Shimons, in a particular town, it's certainly possible that two of them might have wives with the same name, Sarah, the daughter of Rachel. And so it could be that this document that he found, it'd be a huge coincidence, right? That he's delivering a get from, Levi ben Shimon to Sarah bas Rachel, and the one that he lost it, and then he picked up another one, and it's somebody else's get, a Levi ben Shimon that was meant to be delivered to a Sarah bas Rachel who also lost the get, but you can't be sure. Okay. So here we're dealing with the question of the agent loses the get and then he finds it again. So a big question is going to be, where did he find it again? Was it in the public thoroughfare? Was it in a place where lots of other people could have lost documents? Has anyone else come by? Etc. Let's look into it. Here's the Gemara on Mishnah number 3. Now the Mishnah teaches that if a bill of divorce was lost before being received by the woman, it is invalid unless it was found immediately. And so right there, that is going to, answer our question about if we find it, should we give it to the woman? Well, what they're saying is, well, even if you give it to the woman, it's not going to create a divorce, right? Because it wasn't sent to her by the agent that her husband appointed. It was lost for some amount of time, before you found it and came along. It's not going to be valid. But that's a separate question than whether we should return it or not, and who should we return it to. But we're not doing this from the point of view of us, the finder, right? We're doing it from the point of view of the agent who had this job of delivering the get to her, and he lost it, okay? So let's do that. Now, the Mishnah teaches that if the get was lost before being received by the woman, it is invalid unless it was found immediately. And the Gemara raises a contradiction from a Mishnah in Bava Metzia, page 18a. If one found bills of divorce or bills of manumission, wills, right, like a will and testament, deeds of gift or receipts, this finder should not return these items to the one who is presumed to have lost them. So now it is from our point of view as the finder. As I say, it is possible that they were written and then the writer reconsidered about them and decided that he would not give them, right? So now it's the example the way I explained it at the beginning, right? So should we deliver it? But maybe the husband changed his mind, and if we delivered it, we're creating a problem. So that's why, even though it's a big, big Torah commandment to return lost objects, right? If you find an object that belongs to somebody, it's a mitzvah to return it to its owner. That goes for a bag of money, that goes for a lost animal, that goes for a lost coat, etc. But documents have this extra characteristic that they might not, maybe they shouldn't be found. Maybe it's a problem if they're found in return. Right? And this this Mishnah in Bava Metzia 18a continues, right? So if one found bills of divorce or bills of manumission, wills, deeds of gift, receipt, the finder should not return these items to the one who is presumed to have lost them. As I say, meaning the Tana of this Mishnah, It is possible that they were written and then the writer reconsidered about them and decided that he would not give them. Now, one could infer from this Mishnah as follows, but if the writer said, give these found documents to the intended recipient, one gives them. And this is true even if a long time passed since they were lost, and there is no concern that perhaps this document belongs to someone else with the same name. Right, so there's several issues at play here. If, right, the way I originally put it, you find a get that says it was written by so-and-so and it was intended for such and such woman. So according to this, the Mishnah in Bava Metzia, you should go to the husband and say, is this your get? And give it to him. Don't give it to the wife where you're creating a problem. If the husband then says, that is my get, it was supposed to go to my wife, could you please give it to her? Then it would be all right to give it to her because presumably you become his agent at this point properly to deliver it, but you wouldn't just go give it to her. At any rate, they're using that teaching to address the issue of should we be concerned that this get, which seems to be for this husband and that wife, might actually belong to another couple who has the same names. It seems like that Mishnah Bava Metzia is not concerned with the issue of get for other people with the same names, but rather should we return it to the person who wrote the document, and may we then give it to the intended recipient. Now, Rabbah said about this contradiction that our Mishnah here in Gittin, we should be concerned that people with the same names lost their get, and and the agent who lost the get didn't find the same get that he lost, and that seems to be a contradiction between this other Mishnah about when we find a lost get or other kinds of contracts, and that we should go back to the one who wrote it, right? So Rabbah said, this contradiction, it's not difficult. Here in the Mishnah that rules that the bill of divorce cannot be used unless it was found immediately, right? This is addressing the case of the agent lost the get and then found it again. So it cannot be used unless he found it immediately. Now, this is stated with regard to a place where caravans are frequently found. And there is a concern that the found bill of divorce belongs to someone else with the identical name. There, in the Mishnah in Tractate Bava Metzia, where it say you would take that get and try to find the husband who wrote it, it is stated with regard to a place where caravans are not frequently found. So one may return the document if he knows that the writer did not reconsider sending it, that he didn't lose it on purpose, right? So unless you know, if he knows that the writer did not reconsider, why would you know that? Because you went to him, right? So you would go to the husband and ask him, is this your get? And do you want it back? I guess so you would check with that. But the distinction they're making in terms of are we concerned that somebody with the same name has lost a different, his own, that this document doesn't belong to the guy that we're now going to present it to. Whether or not we're concerned about that is a function of whether we find the get, right, the lost get when it is found. Is it found in a place where caravans come by? Which to the sages meant a busy thoroughfare, a busy intersection, a place where lots of documents could be lost and found. As opposed to, did you find it in the basement of the husband? I mean, it's not like, obviously, if you find the get written by this man for this woman, and you find it in his basement, it's pretty unlikely that it was, some other couple with the same names that somehow came to lose their document in this guy's basement who has the same names. At this point, we'll introduce a concept called dad's observation. My father was just with us for our son's high school graduation, which was a beautiful event. And we were talking about a little Torah over the table. We had a dilemma. We have a book that we like to use at our Shabbos table, kind of like, has dilemmas and what are you supposed to do about it? I can't even remember what the dilemma was. But my father made the observation that, that common sense usually prevails in Talmudic law and in incidents written within the Talmud as illustrations of Talmudic law, that generally speaking, common sense will prevail. Like the answer that you would expect to come ultimately is the answer. Now, I would say that that's not always true, but it is often true. That it is often true. So in that sense, Dad's observation of common sense will probably prevail. Would certainly seem to be the case in terms of, are we worried that this was a get written by other people with the same name? But because a get delivered to the wrong person, or a get that produces a divorce that was not a valid divorce, and the wife might rely on that and go and marry another man thinking she's divorced when she's not, and then if they have children, those children are mamzers. The consequences of that are so grave that the sages will certainly be extremely careful about allowing such a thing to happen. They will be much more stringent than usual when prohibited sexual relationships are in play, right? So if this could lead to a prohibited sexual relationship, in other words, a woman who thinks she's divorced and gets married again, she's actually committed adultery. So lest there be any possibility that that would happen, the sages might go much more stringent than we might at first glance think is necessary. Now, the Gemara comments, and even in a place where caravans are frequently found, there is not always a concern that the bill of divorce may belong to another man with an identical name, but this concern is only where it has been established that there are two men named Yosef ben Shimon, for example, in that one town. Right, so according to some views, you have to have the double condition that the get is found in a public place where lots of documents could be lost or found, and we actually have knowledge that in that locality there are two guys with the same name, who presumably have two wives, each has a wife with the same name, so two couples that have the same names, before we would actually be concerned about this, at least according to some views. Now the Gemara continues, as if you do not say this, that this concern is taken into account only in a place where it is known that there are two people with the same name, then there is a difficulty presented in the form of a contradiction between one statement of Rabbah and another statement of Rabbah, as there was a certain bill of divorce that was found. Okay, now we have an actual incident. There was a certain get, a bill of divorce, that was found, meaning it was brought to the court of Rav Huna. And the name of the place that was written in it was in Shaviri, the city which is on the Rakis River. And Rav Huna said, one is concerned about the possibility of the existence of two cities called Shaviri, and it is possible that this bill of divorce belongs to another man with the identical name. And the Gemara continues, and Rav Chisda said to Rabbah, who was then a student, go out and examine this law, as Rav Huna will ask you about it at night. So Rabbah went out and he examined it, and he discovered a relevant source. As we learned in a Mishna, in Tractate Bava Metzia, page 20a, one should return all court enactments, meaning promissory notes that have been authenticated by the court, to their owner, and there is no concern that perhaps there are two towns with the identical name and that the promissory note belongs to someone else, right? Now, think about a promissory note. That's also a critical document, right? If I lend you money and you write me a promissory note, right? So I hold this note that says you owe me money. This note, right, this paper represents the money that you owe me. Now, if I lose that document, I'm going to have a tough time collecting that money. Now, if somebody finds that document, presumably he should be returning it to me. I'm the owner of the promissory note until you pay me back. When you pay me back, I should give you the promissory note or at least a receipt. That's a whole other argument. Do I give you the promissory note back? Do I give you a receipt that you paid the promissory note? But you see, like maybe you got the note back and then you lost it and then somebody found it and gave it to me. And, I'm a guy who lends money all over town and I don't remember whether I had this promissory note paid off or not. And so I'm like, oh, I guess I must have lost this. Hey, pay me this money that you owe me. You're like, I already paid you. I'm like, I don't remember that. So it can create big problems. Now here, what they're saying is, so promissory notes, maybe you don't return them because it creates that problem. But if it's a promissory note that is a court enactment, right? It was witnessed, it was verified, it was ratified by a court, then it's going to be permissible to return it because there's a lot more sources of evidence to establish what is the status of that note. Now the Gemara explains, but isn't the court of Rav Huna comparable to a place where caravans are frequently found, as there were always many people present there? And yet, Rabbah resolved the question and ruled that one should return the document to the owner, which appears to contradict his earlier ruling that one should not return a document that's found in a place where caravans are frequently found. In other words, if it was lost in a place where, other people might have lost their document, maybe that's one that we should not return because we can't be sure who it belongs to. And a document found near or in the court of Rav Huna, especially if it's found in a court, that's a place where lots of documents come and go, and maybe that's a place where such a document could have been lost. So apparently, Rabbah holds that if it is which appears to contradict his earlier ruling that one should not return a document found in a place where caravans are frequently found. So apparently, he holds that if it is established that there are two people named Yosef ben Shimon, for example, in one town, then yes, there is a concern and the document should not be returned. But if not, then we are not concerned, right? So according to this view and the incident recorded there, it would appear that, we are only going to be concerned and not return the document if A, it was found in a place where there's a lot of coming and going, and B, we don't have knowledge that there are two people with the same name. But unless we have both of those conditions satisfied, we don't return the document lest we open up a hornet's nest. So the Gemara relates that Rabbah performed an action, meaning he issued a practical ruling, with regard to a certain bill of divorce that was found in the flax house in the city of Pumbedisa, in accordance with his ruling of law. As to the details of this incident, there are those who say that this was in the place where people soaked flax, and although it was established that there were two people with the same name living in the city mentioned in the bill of divorce, he ruled this way since it was a place where caravans are not frequently found. And there are those who say that this occurred in a place where people sold flax, and it was not established that two people with the same name lived in the city where the bill of divorce was written, and this occurred in a place where caravans are frequently found. So in any case, he allowed the document to be returned because we didn't satisfy both conditions. Either it was a public place where caravans are found, but we couldn't establish that there's two people with the same name in that city, or there were two people with the same name in that city, but the get was found in a place that is not frequented by a lot of people. Now, concerning this issue, the Gemara relates that Rabbi Zera raises a contradiction between the Mishna and a Baraisa, and then he answers the contradiction. So, says Rabbi Zera, we learned in the Mishnah with regard to an agent who brings a get and it was lost from him and he finds it immediately, then the bill of divorce is valid. And if not, it is not valid. Right? So here we're saying that the operative factor is in terms of an agent who lost the get, is he going to be, and then he finds it again, right? Is he going to be able to deliver it? It's not based on, is this a place where caravans are found or not? Do we know that there's two people with the same name in that city? But rather, did he find it immediately or not? Right? If he found it immediately so that he can be very confident it's the same get, okay, then he can go ahead and deliver it. But if he didn't find it immediately, then it doesn't matter what other conditions there are. It was out of his view for long enough that we should be stringent and not allow him to proceed with a get that might not be the get that he was given to deliver to the wife. It might be a get with the same names, but it was not written for her sake. And that's why it would not produce a valid divorce, even though the agent, the husband, the wife would all think that it was a valid divorce. She would go ahead and remarry and produce a mamzer in that second marriage. Unless that happened, so according to this holding that Rabbi Zera is bringing, it would be if the agent lost track of it for more than a short amount of time, that's it. It's lost. He cannot be used. He can't, even if he finds it again, it can't be used. And Rabbi Zera raises a contradiction to this holding, right? That's our Mishnah. Our Mishnah said if he finds it immediately, okay, and if not, it's no good. That's what our Mishnah here, Mishnah number 3 in chapter 3 says. But Rabbi Zera raises a contradiction from a baraisa, okay? What does the baraisa say? If one found a woman's get in the marketplace, then when the husband admits that he wrote it and gave it, the finder should return it to the woman. If the husband does not admit to this, then he should not return it. Not to this man and not to this woman. So one can infer from here, but when the husband admits that he wrote it, in any event, he should return it to the woman. And by omission, this appears to be the law, even if a long time has passed since the bill of divorce was lost, right? This baraisa just says that if he can confirm that the man wrote it, then it doesn't matter whether he lost it for a short time or a long time, or whether the get was lost for a short time or a long time. The one who finds it can return it to the woman if the husband admits that he wrote it. Now that seems to contradict our Mishnah, which says that a get which was lost can only be returned if it was immediately found, or can only be used, let's say, if it was immediately found. And Rabbi Zera answers this apparent contradiction that he raised by saying, here in the Mishnah where it states that he should not return it because unless he found it immediately, it is stated with regard to a place where caravans are frequently found. And there in the Baraisa where it states that he should return it, it is stated with regard to a place where caravans are not frequently found. Right, so they're adding this external condition, which was not mentioned neither in the Mishnah nor in the Baraisa, about, well, what is the place where it was found? Is it frequented by a lot of people or not? Now we're on 27b, by the way. Now the Gemara compares the rulings of Rabbah and Rabbi Zera. There are those who say, with regard to Rabbi Zera's statement that he should not return it, the one who finds it should not return it in a place where caravans are frequently found. And this is the case when it is established that there are two people in the town with the identical name. In that case, Rabbi Zera holds that it should not be returned. And this is the same ruling as that of Rabbah. And there are those who say in a place where caravans are frequently found, even though it is not established that there are two people with identical names, it should not be returned. And then this disagrees with the ruling of Rabbah, who seems to require both conditions. So the Gemara clarifies, granted that Rabbah did not say a discourse like that of Rabbi Zera and raise a contradiction from that Baraisa. Why? Why didn't he bring that Baraisa to help prove his point? Because Rabbah holds that it is a stronger challenge to raise a difficulty from the Mishnah in Tractate Bava Metzia, because the Mishnah, redacted by Rabbi Yehuda Hanasi, Rebbe, employs more precise language than Baraisas, right? In a face-off between a Mishnah and a Baraisa, generally we're going to say that the Mishnah is more authoritative, and we will hold, if there's no other evidence that we can rely on, Mishnah versus Baraisa, we will go with the Mishnah. So it must be that Rabbah didn't want to bring that Baraisa when he had a Mishnah in hand. Where am I? Hold on. Right. So granted that Rabbah did not say like Rabbi Zera and raise a contradiction from the Baraisa, because he holds it's a stronger challenge to raise a difficulty from the Mishnah in Tractate Bava Metzia, for the reason I just said. But what is the reason that Rabbi Zera did not say like Rabbah and raise a contradiction from a Mishnah? Why did he bring a Baraisa when there was a Mishnah available? And the Gemara answers, Rabbi Zera could have said to you, does the Mishnah teach that if he said, give the found document to the intended recipient, one gives it? And this is so even if a long time passed? Does the Mishnah teach that? This was only an inference from the Mishnah. Perhaps the Mishnah should be interpreted differently so as to teach, if he said give it, then one gives it. But this is only, as we maintain in the Mishnah, when it is found immediately, and not if a long time has passed. So the Gemara offers an alternative resolution to the contradiction between the Mishnah here on the one hand and the Mishnah in Tractate Bava Metzia and the Baraisa on the other hand. Rabbi Yirmiyah said, it is possible to resolve the contradiction in a different way. The latter permit one to return a lost get only in a case where the witnesses who signed the get say, we have never signed the get of Yosef ben Shimon other than this one, in which case there is no concern that the bill of divorce belongs to someone else. Right? If you can get the witnesses, okay, well then I think we're going to be able to clarify, is this the get that this husband intended to give to that wife or not? I mean, I think clearly if we can find the witnesses, if we can find the husband, we're going to be able to clarify this. We're also trying to establish as principles if we can't get a hold of the husband or we can't get a hold of the witnesses, in which case maybe we should just leave that paper alone and not try to get involved and open the hornet's nest. Now the Gemara asks, if that is so, what is the purpose of stating that one returns the get? Since it clearly belongs to her, there is no question that it must be returned to her. And the Gemara answers, it is necessary, lest you say that one should be concerned that perhaps it happened that another get was written, with which the names of the husband and the wife are identical to the names of the husband and wife in the second get, and the names of the witnesses on the one get are identical. I mean, it's getting a little crazy, right? So could there be two gets that represent a divorce between a husband and a wife with exact same names as this husband and wife, and the witnesses of their get have the exact same names as the witnesses of their get? Seems so unlikely. But the consequences of a mistake in this area of law are so grave that maybe we need to be concerned for that. Therefore, the Mishnah teaches us that we are not concerned for that. But we're not going to be concerned. We are concerned that the two couples have the same names, but we're not concerned that the two couples got witnesses with the same names for their respective divorces. Now, the Gemara suggests an alternative resolution to the contradiction. Rav Ashi said, when do the Mishnah in Tractate Bava Metzia and the Baraisa rule that one should return the get? It is in a case where one who lost it says, there is a hole in the get next to such and such a letter, as this is a clear-cut distinguishing mark for him. And the Gemara comments, and Rav Ashi permits the returning of such a get specifically when one says that this distinguishing hole in the paper is next to such and such a letter, as that is a clear-cut distinguishing mark for him. But if he said only that it had a hole without mentioning its precise location, then one should not return the get, as that is not considered a clear-cut distinguishing mark. Let's just read a little side note about distinguishing marks and lost objects. The sages differentiate between three levels of distinguishing marks on lost objects. There is a general description, for example, describing a person or an item as tall or short, which carries no weight with regard to monetary law. On the other side of the spectrum, there are clear-cut distinguishing marks. For example, a hole next to a specific letter in a document, which are certainly considered to be distinguishing marks by Torah law, even with regard to matters concerning Torah prohibitions. Like here, right, is a Torah prohibition, a written Torah prohibition to commit adultery, and that could be the result of delivering the get to the wrong person. So that's the area, this is the realm that we're in. But even where the consequences are so dire as that, we have a principle of clear-cut distinguishing marks. So if this guy's able to say, yeah, the get that I was intended to deliver, or if the husband can say, the get that I wrote, right, it had a hole that looked like this next to such and such a letter. It's very clear-cut. So we would say, okay, we're talking about the same get. That's so at one end, general, we pay no credence to it. The other end, super specific, okay, we can identify the get by that. Now there's going to be that in-between range. The topic under dispute is the category of distinguishing marks, which are not overly general, but are also not particularly unique to the item in question. Some sages hold that such distinguishing marks are accepted as evidence by rabbinic law, and may be relied upon when returning a lost item, because even if there was a mistake, the court has the power to transfer the item from one person to another based upon the principle that property declared ownerless by the court is ownerless. However, such distinguishing marks are not relied upon to rule on matters concerning Torah prohibitions, like prohibited sexual relations, which could result from a mistaken get. As the sages cannot abrogate a Torah prohibition, right? They can't say, well, we declared that it was valid, and so now it is valid. They can't say that because they can't overrule a Torah prohibition. They could only overrule a rabbinic decree. Other sages hold that such distinguishing marks are accepted as evidence, even with regard to matters concerning Torah prohibitions. So you really have to, look at the circumstances in a particular incident and see which precedents apply, which region you're in, who is going to be, the gadol, right, the great rabbi of that generation in that location, whose ruling we're going to follow. There's a lot going on, right? We certainly want to avoid having any kinds of ambiguities like this. So if you're an agent entrusted to deliver a document, don't lose it, for goodness sake. Okay, let's continue. Now the Gemara explains, Rav Ashi is uncertain with regard to whether the obligation to return a lost item to its owner on the basis of distinguishing marks is by Torah law or if it is by rabbinic law, right? I don't think that the Torah says, it certainly doesn't define distinguishing marks. I'm not even sure if the Torah mentions distinguishing marks. What the Torah says is you have to return a lost object to your fellow. Therefore, in the case of a bill of divorce, Rav Ashi holds that one may rely only on clear-cut distinguishing marks, as everyone agrees that the requirement to return a lost item to its owner on the basis of a clear-cut distinguishing mark is by Torah law. Now, apropos this discussion, the Gemara relates an incident. Rabba Bar Chana lost the get that he was transmitting. Okay, here we go. So it can happen even to a sage. He was the agent of delivery. He was transmitting a get. And he lost it. And he lost it when he was in the study hall. He said, if they request a distinguishing mark, I have one for it. If it depends on visual recognition, I have methods of recognition for it. They returned the bill of divorce to him. He said afterward, I do not know if they returned it due to the distinguishing mark that I supplied, and they hold that distinguishing marks are used to return the lost items by Torah law, or if it was due to my visual recognition, and it is specifically Torah scholars like me who are relied upon when they say that they recognize an item, but an ordinary man would not be relied upon to recognize the item and have it returned to him. So he wasn't sure, was it because he recognized, that is the get that I had before, and they returned it to him, but maybe we wouldn't do that for somebody who's not a Torah scholar. Or if it was because he could name clear-cut distinguishing marks, he couldn't remember what it was, so it's hard to learn out what was the principle from that incident. Now the Mishnah teaches that if one found the get immediately, we're back to our Mishnah. The Mishnah teaches that if one found the get immediately, it is valid. But if not, it is not valid. So the sages taught, so what is considered not immediately? Now we're getting away from the inferred conditions of, okay, if he found it immediately, he can, he can pick it up and deliver it. But if he didn't find it immediately, he can't. And we're getting away from the initial interpretation that this is only if it was in that place where caravans are not frequently found. But if it is a place where caravans are frequently found, then he can't pick it up, even if it was immediate. But then we modified that and said, but we're only going to say you can't use it if you find it in a place where caravans are frequently found, if it is also established that there is somebody else with the same name, and that's what we're concerned about. Okay, now we're getting away from that discussion, and we're just getting to the Mishnah itself, which said the agent who lost it can only pick it up and use it again if he found it immediately after he lost it. What does immediately mean? Rabbi Nassim says, it is when there was a delay equivalent to the amount of time it would take for a caravan to pass by and camp there. Rabbi Shimon ben Elazar says there is no fixed amount of time. Rather, it is within the category of immediately, as long as there will be a person that stands and sees that no other person passed there. And some say that he said it is as long as no person stopped there. So Rabbi Yehuda Hanasi says it is within the category of immediately if there was not a delay equivalent to the amount of time it would take to write the bill of divorce. Yitzhak says it is equivalent not to the amount of time needed to write the bill of divorce, but equivalent to the amount of time it would take to read the bill of divorce. And others say it is equivalent to the amount of time it would take to write it and to read it. And the Gemara adds, and even if there was a delay and the bill of divorce has distinguishing marks on it, the marks attest to it and it is considered a valid bill of divorce. And this is the law where the distinguishing marks are clear cut. For example, when they say it has a hole in the paper next to such and such a letter. And one may not testify with regard to distinguishing marks of the physical description of the get itself. For example, where they say the get is long or short, as these are not considered distinguishing marks. In a case where one found a get tied up in a pouch or in a purse or encircled in a ring, and he recognizes the document, or in a case where he found it among his utensils in his house, then even if a long time has passed, the get is valid. It was stated that the Amoraim, the sages of the Gemara, disagreed with regard to the law in this dispute. Rav Yehuda says that Shmuel says the law is that the get is valid as long as no person stopped there. Rabbi Bar Chana says that Rav Yitzchak Bar Shmuel says the law is that the get is valid as long as no other person passed there. The Gemara asks, why is it necessary to state the actual opinion? I'm almost done. Questions or comments, get them in. The Gemara asks, why is it necessary to state the actual opinion? Let this sage, Rav Yehuda, who is citing Shmuel, say that the law is in accordance with the opinion of this sage, the opinion cited as some say. And let this sage, meaning Rabbi Bar Chana, who is citing Rav Yitzchak Bar Shmuel, say that the law is in accordance with the opinion of this sage, meaning Rabbi Shimon ben Elazar. And the Gemara answers, because there are those who reverse the opinions of the Tanaim, they needed to state the opinions explicitly so that there would be no mistake with regard to the law. And the Mishna, our Mishnah, teaches that if one found a bill of divorce in a chafisa, a box, or in a deluskama, which is a will, then it is valid. And the Gemara asks, what is the meaning of the word chafisa? And Rabbi Bar Chana says it is a small flask. And what is the meaning of deluskema? It is a purse of the elderly, which is not the definitions I read in the note on the first page of our daf today. But that's what I've got for us today, and that concludes our discussion of Mishnah number 3 here in chapter 3. Let's check out some comments and questions. Okay, regarding the person who finds the get, Joe, he's not an agent of the husband, the one who found it, nor can he testify that he witnessed the signing. He shouldn't give to the wife, but rather to the husband. If the husband reconsidered the divorce, wouldn't he destroy it? I love your analysis. I think you're absolutely right. I think the question is, that is what he should do, but once the husband has received it back, can he still use that get? Probably not, right? As we're seeing, there's certainly a doubt, right? I mean, it seems like the sages never could, come up with a final ruling on this. I'm not sure. I mean, did we get to the bottom of this? All right, let's just read the halacha as it is stated here in the Koran Talmud next to the Mishnah. In a case, so this is the law, right? This is the law as it came out in the end of the discussion, and this is as would be recorded in Shulchan Aruch. Yes. In a case where a bill of divorce was written in a place where it is known that there are two men with identical names and whose wives have identical names, if one brings a bill of divorce for one of those women and loses it, the bill of divorce is still valid if one of the following criteria applied. 1, if it was found immediately, i.e. the agent saw that no one passed by from the time that the bill of divorce was lost until the time that it was found. 2, if the bill of divorce had a distinguishing mark, or if it was placed in a receptacle that had a distinguishing mark or could be recognized by sight. Conversely, if he does not know that no one passed by and there's no distinguishing mark on the bill of divorce, then there is a concern that the bill of divorce that was found is not the one that was lost. And this is in accordance with the ruling of the Mishna and in accordance with the statements of Rabbah and Rabbi Zera. Now, there are those who rule that if he lost it in a place where caravans are not frequently found, then even if he found the bill of divorce after some time, there is no concern that the bill of divorce that he found is not the one that he lost. And this goes on. But this is all from the point of view of the agent who lost it. And I guess the question is, can he, if he picked it up and thinks he found, it has strong reason to believe that this is the get that he lost and not some other get, can he go ahead and deliver it? But you're addressing sort of the way that I brought up initially, not the agent, just the random guy who finds the get. And what should he do with it? All right? Okay, so here's another law. Here's stated from this point of view. Here's the halacha on that, also from Shulchan Aruch. If one finds a bill of divorce in the marketplace, and the husband admits that he wrote it and gave it to his wife, and he instructs the finder to return it to her, then the finder should return it to her, provided that the bill of divorce was found in a place where there is no concern that it belongs to someone else. And once he gives it to the wife, she is divorced from the time that she receives the bill of divorce. So interesting, if you're the one who finds it, you can't give it to the wife. You have to go to the husband. If the husband says, yes, that is my bill of divorce for my wife, please go give it to her, then you've become the agent of the husband, and it makes sense that you would be allowed to then deliver it to her, but not otherwise. So I would say that, Joe, you got it exactly right. And my father's observation would seem to hold, right? Common sense would dictate, and it does. Joe also says, when finding a get, could it not be given to the local beis din for the judges to figure it out? I would think having a document of this importance should not be floating around in public. Absolutely, I think you could give it to a beis din and let them figure it out. Sure, why not? I think that the reason you're doing that is, right, not because you're somehow delivering it to the beis din on behalf of the husband or something like that. You're just saying, I found it. I don't know what the law is. It's a complicated law. I took Daf Yomi with Sal and Joe, and we discussed this in class, and it was really complicated. I'm not sure what to do with it. You're a sage. You're a Torah scholar. Here's the get. I turn it over to you. I think that might make sense, right? I do think that might make sense. And Joseph says, are there any laws in this tractate that make divorce difficult intentionally in order to discourage it, like with Sota? Right, with the cooling off period, right? That's what, didn't we just talk about that yesterday? At the very least, the husband has to have witnesses to the get. He can't just dash it off and hand it to his wife, right? So we know that there's at least that much that he's going to have to get this get written properly and witnessed before he can hand it off. So there is that aspect. And remember that the ketubah, right, the marriage contract at the outset of the marriage, was written for the purpose of protecting Jewish women so that their husbands couldn't just divorce them willy-nilly in the heat of the moment, because at least they would know that they're going to be financially, set back by starting the divorce, by divorcing their wife. Is going to cost them. So in that sense, it slows it down too. That's what I've got for us today. With God's help, we'll be together again tomorrow at the regular time, 6 p.m. Pacific, for page 28. And